You know that moment when your entire world shifts? When everything you believed about justice, about fairness, about doing the right thing, just crumbles? Well, mine happened on a rainy Tuesday morning in downtown Seattle, when my boss looked me straight in the eye and said, "Vivienne, you're fired, effective immediately." I'm Vivienne Castellanos, and until that moment I thought I had it all figured out. 28 years old, a paralegal at one of Seattle's most prestigious law firms, Morrison and Associates. I'd worked there for 3 years, climbing my way up from filing clerk to handling complex contract negotiations. I was proud of my work, proud of my attention to detail, proud of the fact that I'd caught more legal errors than some of the junior attorneys. But pride, as they say, comes before the fall. The rain was hammering against the floor-to-ceiling windows of the 42nd floor conference room when Harrison Morrison III, yes, the third, delivered my death sentence. He was sitting behind his mahogany desk, his silver hair perfectly styled, his $1,000 suit immaculate. Everything about him screamed old money and untouchable power. "You're kidding, right?" I managed to stammer, my coffee mug trembling in my hands. The Seattle skyline blurred behind him as my eyes filled with tears I refused to let fall. "Do I look like I'm kidding, Miss Castellanos?" His voice was ice-cold, clinical. "Your performance has been unsatisfactory. We're restructuring, and your position is no longer needed." Unsatisfactory. The word hit me like a physical blow. I'd just finished a 70-hour week, had successfully negotiated a settlement that saved the firm's biggest client $2 million, and had personally caught a contract error that would have cost them their reputation. "What about my contract?" I asked, my voice barely above a whisper. "I have a 2-year agreement with specific termination clauses." Morrison's laugh was sharp, dismissive. "Your contract? Miss Castellanos, you're an at-will employee. We can terminate you for any reason or no reason at all. That's basic employment law. But here's the thing. I wasn't just any paralegal. I was the paralegal who had helped draft employment contracts for this very firm. I knew every clause, every loophole, every protection built into those documents. And I knew something Morrison had forgotten. Actually, Mr. Morrison," I said, standing up straighter, finding my voice, "I'm not an at-will employee. My contract specifically states that I can only be terminated for cause, with a 30-day notice period, and with documented performance issues." His face darkened. "You're mistaken. I'm not." I pulled out my phone and opened my photos, scrolling to the copy of my contract I'd saved there. Section 12, subsection A, clearly states that any termination must be preceded by a written warning and a performance improvement plan. "Miss Castellanos," Morrison said, his voice taking on a dangerous edge, "I suggest you clean out your desk and leave the premises immediately. Security will escort you out if necessary." The threat hung in the air between us like smoke. Around the conference room, other employees had stopped their conversations, sensing the tension. I could feel their eyes on me, waiting to see if I'd crumble, if I'd slink away with my tail between my legs like so many others before me. But something inside me snapped. Maybe it was the injustice of it all. Maybe it was the way he'd dismissed 3 years of dedication with a wave of his hand. Or maybe it was the realization that if I didn't stand up for myself now, I'd spend the rest of my life wondering what if. "Mr. Morrison," I said, my voice growing stronger with each word, "I'm not going anywhere. You're in breach of contract, and I intend to hold you accountable." The silence that followed was deafening. Morrison's face went through several shades of red before settling on a particularly unpleasant purple. "Are you threatening to sue this firm, Miss Castellanos?" "I'm not threatening anything. I'm stating a fact. You violated the terms of my employment contract, and I'm going to take legal action to enforce my rights." He leaned back in his chair, a cruel smile playing at the corners of his mouth. "And who exactly is going to represent you? What lawyer in this city would take on Morrison and Associates?" It was a fair question. Morrison and Associates was one of the most powerful firms in Seattle. They had tentacles reaching into every corner of the legal community. Any lawyer who took me on would be risking their career, their reputation, their future. "I'll represent myself," I said, the words tumbling out before I'd fully processed the decision. The silence stretched for what felt like an eternity. Then Morrison threw back his head and laughed. It was a rich, booming laugh that filled the conference room and seemed to echo off the walls. "You? Represent yourself? Against this firm?" He wiped tears from his eyes. "Miss Castellanos, you're a paralegal, not a lawyer. You can't possibly think you can go up against our legal team. Watch me." Those 2 words changed everything. I saw something flicker in Morrison's eyes. Not concern exactly, but a momentary uncertainty. It was gone as quickly as it appeared, replaced by his usual arrogance. "This is your last chance to walk away with some dignity intact," he said. "Take the severance package we're offering, 2 weeks' pay, and sign the non-disclosure agreement. Otherwise, we'll make sure you never work in this city again." I looked around the conference room one more time, at the expensive artwork on the walls, at the view of Elliott Bay through the rain-streaked windows, at the faces of my former colleagues, who were trying very hard to pretend they weren't listening to every word. "Keep your severance package, Mr. Morrison. I'll see you in court." I walked out of that conference room with my head held high, but my hands were shaking so badly I could barely press the elevator button. As the doors closed, I caught a glimpse of Morrison through the glass walls of the conference room. He was already on his phone, probably calling his legal team. The elevator ride down 42 floors felt like the longest journey of my life. With each passing floor, the magnitude of what I'd just committed to hit me harder. I was about to take on one of the most powerful law firms in the Pacific Northwest. With no legal training, no courtroom experience, and no idea what I was doing. But I had something Morrison didn't expect. I had the truth on my side, and sometimes that's enough to move mountains. Walking out into the Seattle rain, I pulled my jacket tighter and made a promise to myself. Morrison thought he could intimidate me into silence. He thought his money and power made him untouchable. He was about to learn that sometimes the smallest person in the room can make the biggest difference. The rain felt like a baptism, washing away my old life and preparing me for the battle ahead. I didn't know how I was going to win, but I knew I was going to try, and maybe, just maybe, that would be enough. The Seattle Public Library became my second home over the next 3 weeks. Every morning, I'd arrive when the doors opened at 10, armed with a thermos of coffee that had to last me until closing time, and a legal pad that filled up with notes, questions, and increasingly complicated legal strategies. I'd never realized how intimidating legal research could be until I was doing it for my own survival. Every case I read seemed to favor the employer. Every statute appeared to have exceptions that could work against me. But slowly, piece by piece, I began to understand the architecture of employment law. My savings account was draining faster than a punctured tire. Without a paycheck, I'd had to move out of my Capitol Hill apartment and into a tiny studio in the International District. The walls were paper thin, the heating barely worked, and my upstairs neighbors seemed to practice tap dancing at 3 a.m. But it was what I could afford, and more importantly, it was walking distance from both the courthouse and the library. The hardest part wasn't the legal research or the financial stress. It was the isolation. Word had spread quickly through Seattle's tight-knit legal community about my lawsuit against Morrison and Associates. Former colleagues stopped returning my calls. Networking events became exercises in being politely ignored. I'd become a pariah, a cautionary tale whispered about in law firm break rooms across the city. But I pressed on, driven by a stubbornness that probably came from my grandmother. Abuela Esperanza had immigrated from El Salvador with nothing but determination and a fierce belief that hard work would eventually pay off. She'd raised me after my parents died in a car accident when I was 12, and her voice echoed in my head during those long library sessions. "Mija, the powerful stay powerful because the powerless stay quiet." I wasn't going to stay quiet. 2 weeks into my research, I made a discovery that changed everything. I was deep in the Washington state employment statutes, cross-referencing termination procedures with civil rights protections, when I found it, a provision I'd never seen before, buried in the anti-retaliation section. It stated that employees who could prove they were terminated in retaliation for asserting their contractual rights were entitled to treble damages and attorney's fees. Not just their lost wages back, 3 times their lost wages, plus all legal costs. My heart started racing as I read the statute again and again, making sure I understood it correctly. If I could prove that Morrison fired me not for performance issues, but because I challenged his authority and asserted my contractual rights, I wouldn't just get my job back. I could potentially walk away with hundreds of thousands of dollars. But proving retaliation would be nearly impossible without documentation, without witnesses, without some kind of smoking gun that showed Morrison's real motivations. That's when I remembered the email. 3 days before I was fired, I'd sent Morrison a detailed email outlining several contract discrepancies I'd found in a major client deal. The email had been professional, thorough, and had potentially saved the firm from significant legal exposure. Morrison had never responded to it, which I'd found odd at the time. I kept a copy of that email on my personal Gmail account, along with several others documenting my work contributions over the past year. If I could show a pattern of excellent performance, followed by sudden termination immediately after asserting my rights, I might actually have a case. But I needed more than just emails. I needed insider information, and I had no idea how to get it. That's when my phone buzzed with a text from an unknown number. Heard about your case. Meet me at Victrola on Capitol Hill tomorrow at 2 p.m. Come alone. You'll want to hear what I have to say. A friend in the legal community. I stared at the message for a long time, my mind racing through possibilities. It could be anything. A trap, a joke, someone trying to gather information for Morrison's team. But it could also be the break I desperately needed. The next afternoon, I sat in the corner of Victrola Coffee, nursing a latte I couldn't really afford, watching every person who walked through the door. At exactly 2 p.m., a woman in her 50s entered, scanning the room with sharp eyes until they met mine. She was impeccably dressed in a charcoal gray suit, her silver hair pulled back in a professional bun that screamed senior partner. "Vivian Castellanos?" she asked, sliding into the seat across from me without waiting for an invitation. "Depends who's asking. My name is Elena Rodriguez. I'm a senior partner at Blackwood and Martinez." She handed me a business card with elegant typography. "And I believe we need to talk." Blackwood and Martinez was Morrison and Associates' biggest rival. If Morrison's firm was old money and establishment power, Blackwood and Martinez was new money and aggressive tactics. The two firms had been at each other's throats for decades, competing for the same clients, the same cases, the same prestige. "Why would you want to help me?" I asked, suspicion creeping into my voice. Elena smiled, and there was something predatory in it. "Let's just say that Harrison Morrison has made a lot of enemies over the years. But more importantly, I think you might actually be right about your case." She pulled out a manila folder and slid it across the small table. "These are copies of internal communications from Morrison and Associates. Communications that suggest your termination wasn't quite as spontaneous as Morrison claimed." My hands trembled as I opened the folder. The first document was a memo dated exactly 1 week before I was fired, from Morrison to his head of human resources. It outlined a plan to restructure the paralegal department, and specifically mentioned the need to eliminate employees who might pose a challenge to firm authority and traditional hierarchies. The second document was even more damning. An email thread between Morrison and 2 of his senior partners discussing what they called the Castellanos problem and strategizing about how to make an example of employees who overstep their bounds and forget their place in the firm structure. "How did you get these?" I whispered, barely able to process what I was reading. "That's not important right now. What's important is that these documents prove Morrison planned your termination before you ever challenged him in that conference room. He didn't fire you for performance issues. He fired you because you were doing your job too well and making him look incompetent." I looked up at Elena, trying to process the implications of what this meant for my case. Why are you giving me this? What do you want in return? Because sometimes the enemy of my enemy is my friend, and because what Morrison did to you was fundamentally wrong. She leaned forward, her voice dropping to almost a whisper. But I need you to understand something, Vivian. This isn't just about your case anymore. Morrison has been getting away with this kind of behavior for years. You might be the first person with both the courage and the evidence to actually stop him. I don't understand. Are you offering to represent me officially? Elena shook her head. I can't officially represent you. Conflict of interest rules would prevent me from taking the case directly. But I can make sure you have access to the resources you need. Legal databases, research assistance, guidance on procedure and strategy. She handed me another business card. This one for someone named Marcus Chen. This is for a brilliant young attorney who just left big law to start his own practice. He's hungry, he's talented, and he absolutely despises everything Morrison represents. He'd love to help with your case. I can't afford to hire another lawyer. He'll work on contingency. If you win, he gets a percentage of the settlement. If you lose, you owe him nothing. It's a risk-free proposition for you. I stared at the documents spread across the table, trying to wrap my head around this sudden turn of events. A week ago, I'd been completely alone, facing an impossible battle with nothing but determination and library books. Now I had evidence, allies, and possibly a real lawyer who knew what he was doing. There's one more thing you need to know, Elena said, standing to leave. Morrison doesn't know we have these documents yet. When you file your amended complaint, including the retaliation claims, it's going to hit him like a freight train. He's used to intimidating people into submission through sheer force of will and reputation. He's not used to fighting someone who actually fights back with real ammunition. As she walked away, I sat there in the coffee shop, staring at the evidence that could change everything. The barista was playing some kind of indie folk music, and outside, the typical Seattle drizzle was painting the windows with streaks of gray. But for the first time in weeks, I felt something I'd almost forgotten. Genuine hope. My phone buzzed with yet another message from Morrison's legal team, demanding I drop the lawsuit and accept their generous settlement offer of 1 month's salary and a confidentiality agreement. I deleted the message without reading it all the way through. They had absolutely no idea what was coming for them. Marcus Chen turned out to be exactly what Elena Rodriguez had promised. Brilliant, hungry, and absolutely ruthless when it came to taking down corporate bullies. We met at his small office in Pioneer Square, a converted warehouse space with exposed brick walls, industrial lighting, and the kind of minimalist aesthetic that screamed, "Young lawyer trying to make a serious statement." "This is absolutely incredible," he said, spreading the documents Elena had given me across his sleek glass desk. Morrison essentially confessed to retaliatory termination in writing. I've seen senior partners make stupid mistakes before, but this is next-level incompetence. Marcus was probably my age, maybe a year or two older, with sharp features and an intensity that reminded me of a caffeinated hawk. He'd graduated from University of Washington Law School at the top of his class, worked for 2 years at a prestigious white shoe firm downtown, then quit to start his own practice when he realized he hated defending corporations more than he loved his 6-figure salary. "Here's what we're going to do," he said, pulling up a legal form template on his computer. "We're filing an amended complaint that includes claims for breach of contract, wrongful termination, and retaliation under the Washington law against discrimination. With these internal memos as evidence, we're asking for treble damages, attorney's fees, and full reinstatement to your position." "Reinstatement?" I asked, confused. "You mean go back to work for Morrison after all this?" Marcus grinned, and there was something distinctly predatory in his expression. "Oh, we're not actually expecting them to take you back, but asking for reinstatement puts them in an impossible legal position. Either they have to admit the termination was wrongful by offering to rehire you, or they have to explain to a jury why they're so terrified of you coming back that they'd rather pay damages." Over the next week, we crafted what Marcus called a legal masterpiece. The amended complaint was 37 pages of carefully constructed arguments, supported by relevant case law and devastating documentary evidence. It told a clear story of an exemplary employee who was terminated not for poor performance, but for having the audacity to know her rights and assert them against a powerful boss. The day we filed the amended complaint, Morrison's response was swift and entirely predictable. Within 3 hours, my phone was ringing constantly with calls from reporters. Apparently, a paralegal taking on one of Seattle's most powerful law firms was considered newsworthy. "I'm not talking to any reporters," I told Marcus during one of our strategy sessions. "Actually, you absolutely should," he replied, leaning back in his chair. "Public pressure is one of our best weapons here. Law firms like Morrison and Associates depend entirely on their reputation for success. Bad publicity can hurt them more than losing a single lawsuit ever could." The Seattle Times ran the story on page 3 of the business section the next day. David versus Goliath. Former paralegal sues prestigious law firm for wrongful termination. The article was fair and factual, but the comments section online was absolutely brutal. Half the readers were cheering me on as someone finally standing up to corporate bullies. The other half were calling me a delusional troublemaker who deserved whatever punishment she got. But the article had an unexpected and incredibly valuable consequence. My phone started ringing with calls from other Morrison and Associates employees, both current and former, who had their own stories to tell about the firm's toxic culture. "Miss Castellanos?" The voice was nervous, barely above a whisper. "My name is Jennifer Walsh. I used to work at Morrison and Associates as a junior associate. I was wondering if we could possibly meet somewhere private." Jennifer turned out to be a former junior associate who'd been systematically pushed out of the firm 2 years earlier. We met at a small, dimly lit cafe in Fremont, far from downtown and the prying eyes of the legal community. "What happened to you is exactly what happened to me," she said, clutching her coffee cup like a lifeline. "I questioned a billing practice that I thought was potentially unethical. Nothing major, just suggested we should be more transparent with clients about certain administrative charges. Next thing I knew, I was being written up for performance issues I'd never had before in my entire career." Jennifer's story was eerily similar to mine. Exemplary performance reviews followed by sudden, inexplicable problems immediately after challenging firm policy, then termination for allegedly unrelated performance issues. "Did you ever consider suing them?" I asked. I thought about it seriously, but Harrison Morrison personally called every major law firm in the city. He told them I was a problem employee who might cause disruption and chaos wherever I worked. I couldn't get a job anywhere in Seattle. I ended up leaving the city entirely, starting completely over in Portland. She wasn't the only one with a similar story. Over the next few days, I heard from a former paralegal who'd been fired after reporting sexual harassment by a senior partner, an IT specialist who'd been terminated after questioning the firm's document retention policies, and 2 secretaries who'd been let go after they'd started talking about forming a union. "This is much bigger than we initially thought," Marcus said when I brought him the growing list of potential witnesses. "Morrison isn't just retaliating against individual employees who challenge him. He's running a systematic campaign to silence anyone who might threaten his absolute authority." But it was the next phone call that changed absolutely everything. "Is this Vivian Castellanos?" The voice was elderly, refined, with a slight accent I couldn't immediately place. "Yes, who is this?" "My name is Dr. Lillian Ashworth. I'm an emeritus professor at University of Washington Law School. I've been following your case in the newspapers, and I believe I have some information that might be extremely valuable to your lawsuit." We met in her office at the law school the next afternoon. It was a cramped space filled with legal treatises, case law books, and what looked like 50 years of accumulated academic papers. Dr. Ashworth was probably in her 70s, with white hair and intelligent eyes behind wire-rimmed glasses. "I've known Harrison Morrison for over 30 years, she said, settling into her chair. "He was one of my students back when he was still Harrison Morrison Jr., and his father was running the firm. What was he like as a student? Brilliant, but fundamentally arrogant. He had a deep-seated tendency to believe rules didn't apply to him, probably because in his experience they rarely did. Old Seattle money has a way of insulating people from normal consequences. She pulled out a thick file folder that looked like it had been waiting decades to be opened. What most people don't realize is that Morrison & Associates has been the subject of multiple state bar complaints over the years. Nothing ever officially stuck. They're exceptionally good at making problems disappear quietly through settlements and non-disclosure agreements. But I've kept track of everything. The folder contained copies of bar complaints, sealed settlement agreements, and confidential court documents spanning 2 full decades. Reading through them was like looking at a detailed pattern of abuse and misconduct that stretched back years. "Why are you showing me all of this?" I asked. "Because Harrison Morrison has spent his entire career using the law as a weapon against people who can't fight back effectively. You're the first person I've seen who's actually fighting back with real skill and determination." She leaned forward in her chair. "But more importantly, because I think Morrison made a critical legal mistake with your employment contract that he doesn't even realize yet." "What kind of mistake?" Dr. Ashworth smiled, and there was something almost predatory in her expression. "Tell me, Miss Castellanos, who personally drafted your employment contract?" "Morrison did. He always personally handles all contracts for senior paralegals and junior associates." "And did you ever notice anything unusual about the specific language used in Section 12? I thought back to the termination clause I'd memorized, the one that specified I could only be terminated for cause with 30 days written notice and fully documented performance issues. "Not really. It seemed pretty standard to me." "That's because you were reading it as a paralegal, not as a lawyer trained in contract interpretation. But I've been studying and teaching contract law for over 40 years, and I can tell you that the way Morrison wrote that particular clause creates what we call an implied covenant of good faith and fair dealing." She pulled out a copy of my employment contract and pointed to the relevant section with a pen. "The language he used doesn't just require legitimate cause for termination. It requires that any alleged performance issues be addressed through a specific, detailed process. By firing you without following that exact process, he didn't just breach your contract. He breached his legal duty of good faith and fair dealing, which under Washington state law opens the door for substantial punitive damages." My heart started racing as the implications hit me. Punitive damages? It gets even better than that, because Morrison wrote the contract himself, and because he's a licensed attorney who absolutely should have known better, his breach could be considered willful and wanton conduct. That opens the door to potentially massive punitive damages. We're talking about hundreds of thousands of dollars. I sat there in stunned silence, trying to process what this meant for my case. Dr. Ashworth wasn't just offering me more evidence. She was offering me a legal weapon that could not only win my case decisively, but potentially cripple Morrison financially. "There's just one significant problem," she continued. "To make this argument stick in court, you'll need to prove that Morrison knew exactly what he was doing when he wrote that clause. You'll need to show that he understood the legal implications perfectly and chose to violate them anyway out of pure arrogance. How do we prove something like that?" Dr. Ashworth's smile turned decidedly wicked. "We make him explain his legal reasoning under oath, in front of a jury, in excruciating detail." As I walked back to my car through the University District, my mind was racing with new possibilities. What had started as a simple wrongful termination case was rapidly evolving into something much bigger and more significant, a chance to expose decades of systematic abuse and maybe, just maybe, bring down one of the most corrupt law firms in the entire city. But first, I had to survive the discovery process and depositions, and something told me Morrison wasn't going to make any of that easy for me. The war was just beginning. The deposition was scheduled for a cold, gray Thursday morning in February in the most intimidating conference room at Morrison & Associates. As Marcus and I walked through the firm's marble lobby, past the oil paintings of distinguished founding partners and the massive wall of awards and accolades, I felt like I was walking directly into the heart of enemy territory. Harrison Morrison was already seated at the head of the polished mahogany conference table when we arrived, flanked by 3 attorneys from his own firm and 2 more from the prestigious outside litigation firm they'd hired specifically to handle my case. He looked supremely confident, almost amused, as if this whole legal proceeding was an elaborate joke, and he couldn't wait to see the punchline. "Miss Castellanos," he said with a condescending nod that made my skin crawl, "I sincerely hope you've finally come to your senses and are ready to discuss a reasonable settlement that works for everyone involved." "Actually," Marcus replied smoothly, "we're here to ask you some very specific questions under oath. Shall we begin?" The court reporter swore Morrison in with practiced efficiency, and Marcus started with basic background questions about Morrison's education, experience, and role at the firm. Morrison's answers were smooth and practiced, the polished responses of someone who'd been through this process many times before. But I could see the subtle tension in his shoulders, the way his fingers drummed silently against the mahogany table. "Mr. Morrison," Marcus said, "you personally drafted Miss Castellanos' employment contract, is that correct?" "Yes, that's correct." "And you're thoroughly familiar with Washington state employment law?" "Of course. I've been practicing employment law for over 30 years. So when you wrote Section 12 of the contract, specifically stating that termination could only occur for cause, with documented performance issues and 30 days written notice, you fully understood the legal implications of that precise language." For the first time since we'd started, Morrison hesitated noticeably. I understood that it provided certain contractual protections for the employee, protections that you chose to completely ignore when you terminated Miss Castellanos without cause. Miss Castellanos was terminated for entirely legitimate business reasons. Marcus pulled out a copy of the internal memo Elena Rodriguez had provided, the damning one discussing the Castellanos problem and the need to make an example of challenging employees. "Mr. Morrison, is this your signature on this internal company memo, dated exactly 1 week before you terminated Miss Castellanos?" Morrison's face went visibly pale as he recognized the document. His lead attorney immediately leaned over and whispered something urgently in his ear. "I'm instructing my client not to answer that question," the attorney said firmly. "That document is protected by attorney-client privilege." "Actually," Marcus replied with deadly calm, "it's not privileged when it constitutes evidence of potential criminal activity, and conspiracy to violate state employment law is indeed a criminal offense in Washington." The room went absolutely silent. Morrison's face was cycling through various alarming shades of red, and his entire legal team was frantically passing notes back and forth like teenagers in detention. "Let me ask you a different question, Mr. Morrison," Marcus continued relentlessly. "Are you familiar with the landmark case of Peterson versus Microsoft, where the Washington Supreme Court specifically ruled that employers who draft contracts with detailed termination procedures must follow those procedures exactly or face substantial punitive damages?" I'm not immediately familiar with that specific case. It was obviously a lie, and everyone in the room knew it. Peterson versus Microsoft was foundational case law that every single employment attorney in the state would know by heart. Marcus pulled out another document with theatrical precision. "This is a copy of a law review article you personally wrote and published in 2018 about employment contract interpretation. In it, you specifically cite Peterson versus Microsoft and discuss at length the critical importance of following contractual termination procedures. Do you remember writing this article?" Morrison was completely trapped, and the panic in his eyes was unmistakable. If he admitted to knowing the case law, he'd be admitting he knowingly and willfully violated it. If he denied writing the article, he'd be committing obvious perjury in front of multiple witnesses. "I may have written something along those lines," he said finally. his voice barely above a whisper. "So you were fully aware, when you terminated Miss Castellanos without following the procedures explicitly outlined in her employment contract, that you were deliberately exposing your firm to substantial punitive damages under Washington law?" "That's not—" The situation was completely different. "How exactly was it different, Mr. Morrison? Please explain to us how this situation was different from the legal principles you yourself wrote about." And that's when Harrison Morrison made the catastrophic mistake that would ultimately cost him everything he'd built. "Because she was just a paralegal," he snapped, his carefully maintained composure finally cracking completely. "She had absolutely no right to challenge my authority in front of the entire firm like that. She needed to be taught a lesson about knowing her place and respecting the hierarchy." The silence that followed was absolutely deafening. Even Morrison's own attorneys looked genuinely stunned by what he'd just admitted. In one moment of uncontrolled anger, he'd confessed to everything: retaliation, discrimination, willful violation of contract law, and complete disregard for basic employee rights. Marcus let the silence stretch uncomfortably long, then said quietly, "No further questions, Your Honor." The trial began 6 weeks later, and by then, word had spread throughout Seattle's legal community about Morrison's devastating deposition testimony. The courtroom was packed every single day with lawyers, law students, journalists, and curious members of the public. The case had become a symbol of something much larger: the eternal struggle between powerful institutions and the brave individuals who dare to challenge them. Judge Patricia Hendricks was presiding, a no-nonsense woman in her 60s who'd built her sterling reputation on absolute fairness and complete intolerance for courtroom theatrics. She'd clearly read all the case files, reviewed all the evidence, and had apparently decided this was going to be a trial focused strictly on facts and law, not personalities or grandstanding. Morrison had hired the absolute best defense team money could buy, led by Amanda Sinclair, a legendary litigation partner from a prestigious national firm. She was brilliant, aggressive, and absolutely ruthless in cross-examination. Her opening statement painted me as nothing more than a disgruntled employee trying to cash in on a routine business decision through frivolous litigation. But Marcus's opening statement was absolutely devastating. He methodically laid out the evidence, the consistently excellent performance reviews, the internal memos planning my termination, Morrison's own recorded admission that he fired me to teach me a lesson, and most importantly, the contract language that Morrison himself had written and then deliberately violated. "This case isn't just about Vivian Castellanos," Marcus told the jury with quiet intensity. "It's about whether powerful people have to follow the same rules as everyone else in our society. It's about whether contracts have any meaning when the person who wrote them decides they don't want to honor them anymore because they're angry." The trial lasted 8 grueling days. Morrison's defense team brought in expert witnesses, character references, and former employees, all trying to paint him as a pillar of the legal community who'd simply made an honest mistake in judgment. But the evidence was overwhelming, and Morrison's deposition testimony played in court like a full confession. The moment that absolutely sealed the case came when Dr. Ashworth took the witness stand. She explained, in terms any layperson could easily understand, exactly how Morrison had written a contract that legally bound him to specific procedures, then deliberately ignored those procedures because he was angry at an employee who dared to assert her rights. "In over 30 years of teaching contract law," she told the jury with quiet authority, "I've rarely seen such a clear-cut case of willful breach of contract. Mr. Morrison didn't just break the contract by accident. He broke it maliciously, with full knowledge of the legal consequences, because he was more concerned with punishing Miss Castellanos than following the law." When the jury returned after deliberating for less than 4 hours, their faces were serious but absolutely determined. Judge Hendricks asked the foreman to read their verdict. "In the matter of Castellanos versus Morrison and Associates, we find for the plaintiff on all counts. We award compensatory damages in the amount of $75,000, punitive damages in the amount of $500,000, and attorney's fees in the amount of $125,000. The courtroom absolutely erupted. Morrison's face went white, then red, then back to white again. His legal team looked like they'd been hit by a freight train. Meanwhile, Marcus was grinning like he'd just won the lottery, and I was trying desperately not to cry tears of joy and relief. But the real victory came 3 months later, when the Washington State Bar Association announced they were opening a formal investigation into Morrison's conduct. The comprehensive bar complaint filed by Dr. Ashworth and several other legal ethics professors cited my case as clear evidence of a systematic pattern of professional misconduct spanning decades. Harrison Morrison III resigned from his own firm exactly 6 months after the trial concluded. He agreed to a 5-year suspension of his law license and payment of a substantial fine to the State Bar's Client Protection Fund. Morrison and Associates, facing multiple new lawsuits from former employees who'd found the courage to come forward after my case, eventually settled all outstanding claims and implemented comprehensive new employment policies overseen by an independent outside monitor. The firm's reputation never fully recovered. Within 2 years, they'd lost most of their major clients and were forced to merge with a smaller practice just to survive. The Morrison name, which had been synonymous with legal prestige in Seattle for 3 generations, became a cautionary tale whispered about in law schools across the country. As for me, I used part of my settlement money to enroll in law school at the University of Washington. It turns out that representing yourself in a high-stakes legal battle, while absolutely terrifying, is excellent preparation for legal education. The experience had taught me more about contract law, civil procedure, and courtroom strategy than most first-year students learn in their entire academic year. I graduated summa cum laude 3 years later and immediately joined the Elena Rodriguez's firm, Blackwood and Martinez, where I now specialize in employment law and workplace discrimination cases. It's incredibly satisfying work, helping people who find themselves in situations similar to what I experienced, giving them the legal ammunition they need to fight back against powerful employers who think they're above the law. But perhaps the most rewarding part of my new career came just last month, when I received a phone call that brought everything full circle. "Miss Castellanos?" The voice was young, nervous, with the slight tremor that comes from desperation and fear. "My name is Rebecca Thornfield. I'm a paralegal at Whitman, Sterling and Associates downtown. I was wondering if we could possibly meet to discuss something that happened at my firm." Rebecca's story was heartbreakingly familiar. She'd been working at her firm for 2 years, consistently receiving excellent performance reviews and handling increasingly complex cases. But when she'd questioned what appeared to be fraudulent billing practices, charging clients for work that had never actually been performed, she'd suddenly found herself under intense scrutiny. "They're saying my work quality has declined dramatically," she explained as we sat in a quiet corner of the same coffee shop where Elena Rodriguez had first approached me years earlier. "They're documenting every tiny mistake, timing my lunch breaks, questioning every decision I make. I know they're building a case to fire me." "Tell me about your employment contract," I said, pulling out a legal pad that had become as familiar to me as breathing. "Did your boss write it personally?" "Actually, yes. The senior partner, Gregory Whitman, handles all employment contracts himself. He's very particular about the language." I smiled, feeling that familiar surge of anticipation that comes when you realize you're about to help someone fight back against a bully. "Rebecca, I think we need to take a very close look at that contract. And I have a feeling Mr. Whitman might have made some of the same mistakes that cost Harrison Morrison his entire career." As I reviewed Rebecca's employment contract later that evening in my office, I found exactly what I'd hoped to find. Overly specific termination procedures, detailed performance improvement requirements, and language that created multiple legal protections the employer would have to navigate carefully to avoid liability. Gregory Whitman had made the same classic mistake that powerful people often make. He'd gotten so comfortable with his authority that he'd forgotten the law applies to everyone equally. The next morning, I filed a preemptive lawsuit on Rebecca's behalf, citing the same retaliation and breach of contract theories that had been so successful in my own case. The local legal community was buzzing within hours. Apparently, the David versus Goliath dynamic never gets old, especially when David keeps winning. But the real satisfaction came 2 weeks later, when Gregory Whitman's attorney called to discuss settlement negotiations. My client is prepared to offer a substantial settlement to resolve this matter quickly and quietly, the attorney said during our phone conference. That's interesting, I replied, leaning back in my office chair and gazing out at the Seattle skyline. But we're not particularly interested in settling quickly or quietly. Your client has been systematically retaliating against employees who report ethical violations. We think a jury should hear about that. The silence on the other end of the line stretched for nearly 30 seconds. What would it take to resolve this matter? The attorney finally asked. Full reinstatement with back pay, implementation of new workplace policies overseen by an independent monitor, and a public apology acknowledging that the retaliation was wrong. Oh, and attorney's fees, of course. That's quite a lot to ask for. Actually, I said, thinking back to that rainy Tuesday morning when Harrison Morrison had destroyed my life with a few casual words, it's exactly what justice looks like. They accepted our terms within a week. 6 months later, Rebecca was back at work with a promotion and a raise. The firm had implemented comprehensive new policies protecting employees who report ethical violations. And Gregory Whitman had issued a public statement acknowledging that retaliation against whistleblowers was both legally wrong and morally indefensible. The Seattle legal community had learned an important lesson. The days when powerful law firm partners could destroy employees' careers with impunity were officially over. As I finished updating Rebecca's case file and prepared to leave the office that evening, I thought about the strange journey that had brought me to this point. 5 years ago, I'd been a paralegal living paycheck to paycheck, terrified of challenging authority, convinced that people like Harrison Morrison were untouchable. Now I was a successful attorney with a thriving practice, helping other people find their voices and fight back against workplace bullies. I discovered that the legal system, despite all its flaws and complexities, actually works when people have the courage to use it properly. My phone buzzed with a text message from an unknown number. Saw the article about your latest case in the Seattle Times. Proud of how far you've come. Keep fighting the good fight. E.R. Elena Rodriguez. Even now, years later, she was still watching out for me, still supporting the fight against powerful people who abused their positions. I smiled as I gathered my things and headed for the elevator. Tomorrow would bring new cases, new challenges, new opportunities to help people who thought they were powerless discover that they actually had more strength than they'd ever imagined. The rain was falling steadily as I walked to my car, but it didn't feel like the cold, depressing Seattle drizzle I remembered from those dark days when I was unemployed and fighting for my survival. This rain felt cleansing, renewing, full of possibility. Harrison Morrison had laughed when I told him I'd represent myself in court. He'd thought a paralegal could never take on a powerful law firm and win. He'd been absolutely convinced that his money, his connections, and his reputation made him untouchable. He'd been wrong about everything. And his arrogance had cost him not just a lawsuit, but his entire career, his firm's reputation, and his legacy. Sometimes the most powerful people make the biggest mistakes. They get so comfortable being above the rules that they forget the law was designed to protect everyone equally. And sometimes, when someone finally has the courage to stand up and fight back, justice actually wins. Even if you have to do it completely alone, even if everyone tells you it's impossible, even if the odds seem insurmountable, sometimes the little guy really does win. And when that happens, it changes everything.